calling it like it is, bringing the community together and working for justice. Attorney Travis McConnell talks politics, trending news, and how you can make a difference. You're listening to We Trust Travis.
Hi, everyone. I'm Serena Fazan, a journalist, host, and producer. Thank you so much for joining us for this episode of We Trust Travis. Travis McConnell is a personal injury attorney with a huge passion for the community, and he has a lot of insight to share. So let's get right to it. Travis is joining us from Indiana, and sitting next to me in the studio is criminal defense expert Paul Cisco. Paul, thank you so much for being here.
Good morning. Thank you.
Travis, how are you?
Doing well, Serena. Thanks for having me again, and thanks for hosting.
Thank you. And just share a little bit about yourself, Travis. You, of course, practice law here in the state of Florida, but you're also in Indiana. So tell us about yourself.
Yeah, so I'm an attorney that's licensed in 2 states, Indiana and Florida. First was licensed in Florida and lived there for 7-8 years. And then I'm originally from Indiana, moved back home to raise my kids closer to their family. And I do predominantly personal injury law and a little bit of criminal defense in the state of Indiana only, not in Florida, because you have to get into the courtroom a lot more often. And I'm mostly in Indiana nowadays with my kids and family. So,
well, I'm honored to host your show. And on this show, you invited Paul Cisco here. Paul, why don't you first tell us a little bit about yourself before we get into the subject of the show?
Well, thanks. Always good to see you and Travis. I've been practicing in the Tampa Bay area 29, 30 years. I do primarily white-collar criminal defense, but I also do a general practice criminal defense and do a fair amount of civil also. And happy to be here and happy to see my friend Travis up in Indiana.
Thank you so much, Paul. And you're also a former prosecutor, so you can give us both sides.
I am. You know, as many of us are here that do criminal defense, we kind of saw how the sausage was made back in the old days when we were prosecutors, and we kind of gotten on the other side, and you know, it's our job to take the sausage apart now or eat it.
Well, I'm looking forward to this show because Travis wanted to discuss what are the U.S. constitutional amendments 4th, 5th, and 6th, and how do they impact you? Travis, why did you think it was so important to do a show on these specific amendments?
Well, I mean, we wanted to do a show about your rights as somebody who's potentially accused of a crime. And a lot of those rights come from the 4th, 5th, and 6th Amendments. It's the kind of the bread and butter of criminal defense law, where a lot of stuff comes from. And each state will usually apply them, but usually it kind of mirrors the federal 4th, 5th, and 6th Amendments in the U.S. Constitution that have been there since the bedrock foundation of our country. They go to unreasonable searches and seizures, your right to remain silent, your right to have a lawyer. They're basically the bedrock foundation of your rights as somebody who's accused of a crime by the government.
So on that note, Paul, why don't we go through each of these amendments that Travis wanted to delve deeper into.
Sure.
Why don't we start with the 4th Amendment?
Well, you know, just from an overview standpoint, as we look at these, you know, the difference really between the American system of jurisprudence and others is it's never the accused's burden to prove their innocence. You know, it's the government's burden to prove their guilt or their culpability. And so the 4th, 5th, and 6th Amendments are what guarantee that. And essentially what it means is the 4th Amendment, going way back to the founding fathers, they saw, look, before you're going to be able to search someone's house or you're going to be able to search their possessions, we have to have an independent magistrate look to see whether probable cause exists so that we can get a search warrant to do that. And, you know, that goes to the premise they were living under a king in England. They wanted to leave there. So they come here. We're not going to let some politician or some, you know, non-neutral policeman decide they're going to come inside our home and just ransack it randomly. You have to present, you know, under the 4th Amendment, genuine probable cause. Prove to me that they're going to find something illegal there and what it's based on before I give you this warrant and permission to go in. And so 4th Amendment case law, which we see on TV as, hey, that evidence got suppressed. Why did it get suppressed? Sort of a bedrock principle of criminal law. The 4th Amendment is what protects us from unreasonable searches and seizures and requires an independent judge or magistrate to look at the evidence before that search can happen.
Well, times are changing so much, and Travis, you had mentioned that right now there's a huge concern, correct, with electronics and your phone, and can they search your computer or can they search your text? Isn't that, you wanted to delve deeper into this because of that very topic?
Well, I know it's something that has evolved over the years. So it started, like Paul indicated, back in the day when we were worried about the king sending his soldiers in, or the new quote unquote kings, the representatives sending the police in, and to your home. And the home is the most protected, but it's evolved with technology as times have changed to include so much. I mean, there's your home, there's your vehicle, there's other things like that, and then like with today with your phone, you can potentially get a warrant to take someone's phone, but you may not actually be authorized to look inside the phone. Then it's like, what about the data that's actually stored on the phone? That's separate from the actual phone itself. And you might need to be able to prove to like get an additional warrant potentially to actually search the data on the phone as opposed to just taking the phone itself.
Yeah,
And all those sorts of things.
Travis hits on a very good point. So the Fourth Amendment, like no other piece of law I know, evolves more over time than almost any of the other constitutional amendments, because when they first decided we're going to have an independent magistrate look at things before there's a warrant, they didn't think, hey, can you search a car? A car is essentially the home. Places where there's an expectation of privacy now have evolved into the areas we look at in the Fourth Amendment. Do I have, for instance, a reasonable expectation of privacy on my cell phone? Do you have one on your laptop there? And certainly you do to some degree. And so the Fourth Amendment and the case law which has come about as a result of it, has to change over time. We were, many of us had 8-track tapes not too long ago, and now we're past analog and we've got digital technology now. Does that warrant give me permission to, get you to put your password in so I can search your computer? There's a lot of nuance to it, and the essence of it is, you have a right to reasonable expectation of privacy in what's private, and we're not going to just let the government come into it because the government wants to. The Fourth, Fifth, and Sixth Amendments, I think Travis would agree, and I'm certainly like this right now. They didn't trust government, okay? They came here because they didn't trust government. So let's have independent entities say whether or not the government can get into my stuff. And that evolved from, the frontier home to carriages, to cars, to your iPhone. And it's always evolving because of that.
Travis, you had some thoughts, I think, that you wanted to get in.
No, I think Paul kind of covered it. I was going to say, like, the issue now is with the reasonable expectation of privacy. Like, one, just to, I guess, go into a little bit more detail, but he mentioned passwords. So, like, if you have a password on your device versus if you don't, well, that's a pretty good, clear indicator that you thought that you wanted it to be private. You put a password on it versus if you didn't. One of the things that'll come up in Fourth Amendment situations is things that are in plain sight that don't really require much of a search. Like, if the police come into an interaction with you and there's drugs or whatever that something illegal that they can see in plain sight that's not hidden, okay, well, there's not a reasonable expectation of privacy. I didn't actually have to do much of a search. I just saw it right there. So if I suppose maybe your laptop is open and something's on it that I can see, is that a search or is it something that's in plain sight? And we get into all sorts of technical details there. But I mean, being required to force to give your actual password, like you need to give me your password so I can get this, or that sort of thing as well.
Well, as Travis says there, and he brings up a good side issue related to it, which is there's exceptions, many exceptions to the Fourth Amendment where you don't have to have a warrant. One of them is plain sight. If I'm walking past your SUV and I see you have, 4 kilos of heroin in the back, I don't need a warrant.
Because you're seeing it.
I've seen it in plain sight. I can get in there and I can require you to either open that door or I can get that open. But that changes as time goes by. What becomes plain sight, right? Say I have a drone. So now I'm going to fly a drone over your backyard out in the woods in North Carolina, and I see that you've got 4 acres of marijuana you're growing there. Plain sight changes its definition as time goes by. We have the ability right now pretty much to see anything that's not covered. There was a time before drones where they used to measure infrared heat to find grow houses, for instance, and you could see the infrared heat from the lighting that was inside the home. It's much easier now, and it's harder for that kind of illegal activity to be concealed. And so we're constantly changing what fits the exception to the rule. And so it's sort of a fascinating but very large volume of case law.
Well, there were two questions that immediately came to mind. One, Paul, you had mentioned this. How is the government doing, though, keeping up with this, with this ever-changing cycle? Do you think they're doing a good job? And is there a difference in states, like from Indiana to Florida?
And I'll ask Travis about Indiana, but if you ask me, as you've found over the years, Serena, if you ask me how the government's doing, I'm not a big fan of the government generally. I don't think the government does a good job at much of anything, but they do the best they can with the situation they have generally. They're usually behind the technology curve. The legislation, because it takes a while to get legislation passed, is often behind. It took a long time before there was any legislation at all regarding drones or cell phones or any of that stuff, because they're still back in the analog era on the legislation. And so, no, I don't think the government does a good job, but I do think that the intent of most law enforcement, like any occupation, 95% of them want to do the right thing and want to follow the law. It's the 5% that are sort of on the fringes that you have to distrust in terms of what they're putting into those police reports and the probable cause applications for searches.
Travis, your thoughts on that?
Yeah, I think Paul's right that the government's usually behind due to a variety of reasons. The government responds to society as opposed to being proactive generally. So you see changes come later. I think they try and keep up, and yeah, I don't have much to add on that. I think that most police officers are wanting to do the right thing, or at least what they feel is the right thing in the particular situation. And they try to be aware of the law, but as Paul indicated, like, the law changes fairly often. And what they might have been able to do yesterday, they can't do today, or what they did last year. And I think one thing that the government's not really great at is educating them on, making sure that they're aware of that. Sometimes they'll find it out the hard way in a suppression hearing, where now somebody who very well may have been guilty, but due to the fact of the evidence getting suppressed, is now going to be found not guilty, because now the state can't prove their case, and they're going to get a walk free when potentially they arguably shouldn't have been able to, but for the legal violation that the officer didn't really know about. So one thing that the government's, I think, particularly not as great at is educating the law enforcement on how they need to handle the procedure to make sure that evidence can be used in court.
Well, that's an excellent point Travis makes, because many times, even as a prosecutor, I used to think this is, there's a lot of time put in on the gun range and put in on technical aspects of being a law enforcement officer. But, we used to have a saying as a prosecutor: that guy likes to catch fish, but he doesn't like to clean them, and catching fish, what law enforcement does, and bringing them to arrest is a long way from cleaning that fish and bringing it to the table. You got to be able to finish up that project, and that's really what prosecutors do. There's many law enforcement officers in this county in Hillsborough, candidly, and up in Indiana where Travis is, that have never testified in a courtroom. It's just the nature of the institution. Many of them, they might have testified in a deposition or so along the way, but you get a great cop many times, great detective. He comes in and he's like in a different world when he's in a courtroom, and there's a certain demeanor and a way that they need to present themselves. And frankly, juries, because of TV and otherwise, they expect, that they're going to see, Richard Gere as the detective right there, and he's going to have all the right answers, and he's going to do this. And the reality is, many times they come off, even though they're sharp people, looking like Barney Fife.
And gentlemen, I know we're spending a lot of time on this particular amendment, but I would be remiss if I did not ask this question, because a lot of people don't know what rights do they have. Like, if a police officer, sheriff's deputy says, I need this from you, as a citizen, when do we say no and when do we say yes? I know you talked about plain sight, of course, but it's nerve-wracking,
Well, if an officer is asking you for permission to do something, you can generally almost always say no. Like, you don't have to consent. You should be polite about it, and you shouldn't be resisting or mouthy or rude, because those things will likely get you into an interaction you're not going to like. But you don't have to consent. Like, if can I look in your car? No. Can I come in your home? No. in respond with like, do I need to talk to you? Am I free to go? If you're free to go, like asking that question, am I free to go? Then you can turn around and walk away. Or if the answer is no, okay, so I'm under arrest then. Well, no, well, there's really no in between there. I mean, there kind of is, but like either I'm free to go or I'm under arrest. Which one is it?
Well, and there right there, Travis, is the evolution and the importance of moving from the Fourth to the Fifth Amendment, right? Because the Fifth Amendment then provides that you have a right not to incriminate yourself, okay, which is what most people do. Law enforcement, when they have an idea of what happened, they're going to do everything they can to make you believe that it's in your interest to talk to me, right? Just tell me about it. Why don't you give me consent to look in the trunk? Why don't you tell me what happened? You know, look, we know you're dealing. Why don't you tell me about it? And that's right about then is when that person needs to not say another word, if not before. And because they're looking to prosecute you. There's sort of a feeling, I think, among the general American public, to a certain extent, hey, they're with the government, they're here to help me. The reality is there's a great deal of culpable and guilty parties that talk themselves into convictions, and there's a great deal of innocent folks that either talk themselves into a wrong conviction or put themselves in a position where they're going to have to deal with a crisis and heartache of a criminal prosecution, even if they win, because they could have just kept their mouth shut. You know, I think you know, let me give you an example.
Okay. And a good transition into the Fifth Amendment too, by the way.
Yeah,
Paul. Yeah, but give us an example.
So segues, that's what I'm here for.
Segues, yeah, segues and transitions.
But so there's a great United States Supreme Court case Travis is familiar with out of Ohio called, I think it's United States versus Reiner, R-E-I-N-E-R. It's the shaken baby case. Reiner, who was convicted, and that's how he got his name on the case, was the father. He was convicted of shaking the baby to death. But the babysitter, another last name, 15-year-old kid, 16-year-old kid, originally was a potential suspect in that case, and they put her on in a pretrial hearing, and she asserted her Fifth Amendment rights. Well, the prosecutor said, look, she doesn't have those rights. You know, we're not looking to convict her or anything like that. And the U.S. Supreme Court wisely said, look, the Fifth Amendment is for the innocent as well as the guilty, because prosecutors frequently are wrong. Police are wrong. You know, you never know when they're going to sort of change the crosshairs from that prosecution, you know, look to the babysitter now. So she has a right to assert her Fifth Amendment right. And Reiner stands for that principle. So, you know, the public, I think, thinks, oh, he's taking the Fifth, he must be guilty. Many times I'll have somebody that I know is not culpable, and I want them asserting their Fifth Amendment rights also because they get it wrong.
Let's talk about that, though. And Travis, you know, weigh in. I think the perception, though, as you just mentioned, Paul, oftentimes if people do that and they, you know, and they don't speak, sometimes there's a lot of assumption of guilt.
People are supposed to not use their silence against them, but I think as a general rule, jurors have a hard time with that, and they really want to hear from the defendant. And if they don't hear from the defendant, they're going to make certain assumptions potentially. To have somebody actually not make any sort of assumption whatsoever when they don't hear from that person, I think is hard for people. But that's what we do when we go over jury selection and talk with the jurors about what that means and try and, to the best of our ability, make sure that jurors understand it and are going to be able to do it. But yeah, I mean, I think it's one of those things, more importantly, in that initial interaction with law enforcement versus testifying in court. A lot of times, the Fifth Amendment is more about don't talk to the cops before you talk to me, your attorney. Talking with your attorney, you may well end up deciding, okay, maybe we can go ahead and testify in court because the jury is going to want to hear from us, and you can prepare for it, and you can explain to the person what to expect, all those sorts of things. Because one of the main reasons why you don't want to talk to people is because you're nervous, and you're going to say something just because of nerves that's going to come across wrong. And you don't realize the importance of the words that you're using and that language matters. That if you use, instead of saying this particular vocab word, use this one because of connotation, denotation. Just word choice can make a huge difference with people sometimes. Because that interaction with law enforcement, I think people That's where it's so much more important. Like Paul talked about, they're going to come in, they're going to tell you, look, we already know you did this. Let's just talk about it. What a lot of people don't realize is the police don't have to tell the truth. And I don't think that's necessarily a bad thing. They're there to try and ferret out information. And if they can do that by using these techniques, then that's what our law enforcement does. But you also have the right to remain silent. Just because they say that they know you did it and let's just talk about it, they're saying that as a psychological technique to get you to talk to them, to realize, okay, well, I'm already in trouble. Now I can talk my way out of it potentially. And that very well may not be the case, to where they have nothing. And now you're giving them the information they need to build their case. Whereas before, they don't have that.
Yeah, and I think the common perception is too, the great deal of time in criminal jury trials during jury selection is spent with the judge and the lawyers educating the jury that you understand my client here has no duty at all to take the stand. The government has the burden, so my client can constitutionally sit here, never say a word during this trial. Does everyone agree we can't hold that against this person? We're supposed to guarantee that happens. Now, the reality is they will all then say, oh, yes, I won't hold that against them. I won't. And the practicality of it is that I've seen those jurors, when you tell a jury that you're not going to put your client on, those arms cross and their legs cross, and they're like, what happened to you weren't going to hold it against them? You can see it, that draining from their body at that point. So I think it's important that we understand that it's a presumption of innocence. It's not an assumption of innocence. So in other words, it's a legal device that's created that we're all supposed to follow, but we're also all human. And then there's a reptilian instinct or something that says, hey, how come the dude didn't talk to me himself? And that's something that constitutionally you don't have to deal with, but as a lawyer you better deal with it, because they want to hear from your person many times.
Well, the problem is there's a lot of reasons why somebody may not testify that have nothing to do with the case that they're there for. They may very well have a good explanation that would help to show that they're innocent of this particular crime, but they've been convicted of a felony before. And the state's going to bring that up, and you're worried about them testifying, the prosecutor saying that they're a felon, and then you get lumped in with okay, they're not guilty of this one, but since they did it before, then maybe they're going to be guilty of this one. You're going to have that tendency, well, they broke the law once before, so that goes to show that they probably did it this time too.
Travis, excellent point, because the average person walking into a courtroom doesn't realize that decision has to be made by the lawyer. So Travis has an innocent guy, let's say, on a homicide. He's got 3 prior convictions for drug offenses, 3 prior felonies. That jury is never going to hear that he had 3 prior felonies until he takes the stand. So that doesn't come into evidence until he takes the stand.
And if he takes the stand, then it's out there.
Yeah, and my Aunt Gladys or Travis, many people think that if that person's got a felony prior, they absolutely did this. That dog bit me before, he's going to bite me again, and so there are many reasons, as Travis says, why you're not putting that person on. And unfortunately, most of those presumptions a juror makes weigh against the defendant.
They could just be a horribly nervous person that presents awfully. Right. I mean, it could have nothing to do with it. Yeah.
Another great point.
Yeah.
Another great point. I want to go, back, even before you get into the courtroom. If you say something that incriminates yourself, during the process where you're being arrested, you can't take that back, right? Even though, like, say hypothetically, I had the right not to say it, but I blurted it out, I said it. How hard is it to take back, or can you?
Well, she just opened the door, Travis, did she not, to all of the Miranda law that it takes up libraries, Serena, which is, we all know from cop shows and so on, you have the right to remain silent, Ms. Fazan. Anything you say can and will be used against you in a court of law. Those are the Miranda warnings. There's a whole series of cases where people do blurt out something before they're advised of Miranda. Like, oh, are you, let me give you an example. I had a friend of mine, Chamberlain High School, principal calls him in, says, you know what you're here for, right? He says, yeah, because I broke the window on that portable. He's like, no, I want to talk to you about the math test. And so, people make spontaneous mistakes about things, and they blurt things out before they are advised of their Miranda warnings. There's all kinds of exceptions that allow those statements in if they were made spontaneously. But you're right, they can be suppressed many times, or you can go back and say, here's why I said that, or Your Honor, these were made before he received his Miranda warning, so he wasn't properly advised that he didn't have a duty to talk to them. But, the Fourth Amendment law and then that Miranda wing is a big one, that exists also. It goes back to a case from the 60s, an Arizona case called Miranda, where you have a right to be informed of what all Americans should know anyway, but they don't, which is shut your mouth, right?
And even when they're warned, they still don't know.
Right. And in fact, the very wording of it is designed to get you to talk. It's like, how can we word this so that we can tell you have a right absolutely not to incriminate yourself, but then I'm going to get you to talk. So it usually goes something like, hey, look, you can go this way if you want. I got to inform you of your Miranda rights. If you want to be dumb and not talk to me, that's kind of how it gets placed to the person. Right. And then they're like, oh, I better talk. But the reality is they're constitutionally required to tell you it's in your best interest. And by the way, you have a constitutional right not to talk to me. But let's now get down to convicting you.
So the best advice is just don't say anything and call an attorney.
Yeah, most of the time. Yeah. Most of the time. Like although there's instances where you can say, hey, look, I've got the video of this guy next door doing this. I mean, there's exceptions to the rule, but generally, as my assistant will say, I'm off the phone going, why did this person talk to them? And so in the great bulk of times, you're wishing they would just exercise their constitutional right, their Fifth Amendment right, not to implicate themselves.
Yeah. And the big question on whether or not you can back out of a statement is if Miranda was administered, like Paul's saying, but that timing comes in, like, are you in custody or are you not in custody? If you're in custody, then you're supposed to be given that warning. But they'll argue, well, they weren't in custody and it was just like a friendly encounter and they blurted it out. And there's all sorts of complex nuances of the case law. I saw you ask the question and watching Paul's reaction. I'm like, well, there's the lawyer's answer. The lawyer's answer is always, it depends. It's going to depend on the particular facts. But yeah.
Right. Yeah. To Travis's point, FBI policy lately is they'll bring two people to your doors, very nicely dressed. They won't read you Miranda, and then they'll say, hey, well, you were free to go. We're just here to talk. And that's the nature of the agency, right? They're doing longer term, oftentimes white-collar cases. They're not going to arrest somebody right away. So they'll just say, hey, it was a non-custodial interrogation. And so, it's an adversary process. So the defense is always trying to do this to ensure the person's rights, the accused, and the government, because it's their job, are going to do everything they legally can do to try to get that person to trample their own rights. You can always consent to giving up your rights, and they frequently do.
It can be very intimidating.
Sure.
Well, let's talk about the Sixth Amendment, and we're going to devote a whole show about COVID in the courtroom. So we'll save that and how it's impacted trials and things like that. But talk to us about the Sixth Amendment and your right to a speedy trial.
Yes, so the Sixth Amendment guarantees a number of things. There's the right to a trial by a jury, a speedy trial. The jury is, of your peers. And then it also guarantees you the right to counsel in a criminal proceeding. So the jury right was basically, again, back to the idea that the king would appoint the judge, and we don't want that sort of system to happen. We're getting out from under that system. We want this to be regular people from our community who get to decide what happens as your right to a jury trial. And it's one of the, not just criminal right, but a civil right as well, that we get to have the right to trial by jury. And even in the civil situation, corporations are working to try and erode the right by making, mandatory binding arbitrations, things like that, to get out of the court system. They're not fans of the jury. They like to do things more, expeditiously and have business-oriented arbitrators decide as opposed to regular folks like you and me.
Yeah, it's a sacred one. When you say, Travis, that right to a jury trial is so important to an accused or a person who's been sued liably or a plaintiff. The idea is, as Travis said, I don't want the government-appointed entity to decide. I want 6 or 12 people that are like my client, a jury of his or her peers that are going to sit in judgment. The Sixth Amendment also provides, importantly from the criminal aspect, that you have a right to confront the witnesses against you, right? I mean, the guy can't submit an affidavit, hey, this Aunt Gladys in California submits this affidavit, says you did this stuff. And you're like, well, I'd like to be able to cross-examine Aunt Gladys about that. Well, you can. Under the Sixth Amendment, you have a right to confront your accusers, and which allows you to do the most important part, which is the crucible of truth, as the cases say, is cross-examination. It's the same thing when Dad used to call, the kids into the living room and wants to know who ate all the ice cream, and my brother'd lie, but you'd cross-examine them with questions, and maybe one of us has some ice cream on our mouth still, and we weren't supposed to be in there, and you use, hey, what's that on your, on your face? It's a very, it's a very good way of getting to the truth of what happened, and the Sixth Amendment allows us to confront and cross-examine witnesses. So another important aspect. I mean, the Fourth, Fifth, and Sixth Amendment are sort of the Ten Commandments in 3 amendments to the criminal defense, and also on this with tremendous civil implications also. But it really are the hallmarks of the criminal world.
Yeah. And the right to confront the witness is something that's become so interesting, and as far as like what does that mean, because there's victim rights that have come up as far as like children that have been abused. Do they have to actually take the stand and have to deal with being confronted by this person who's been abusing them? Do you have that right to see them face to face, or can they like go through technology and be behind a screen in another room separate so they're not in the same room potentially? And that's been something that's been litigated by people. And then obviously we'll talk about it in a separate episode, but masks and, hiding behind a mask potentially as opposed to not having a mask. So
lots to talk about on that episode, because I think we can carry the Sixth Amendment into the episode on COVID in the courtroom, because that also affects speedy trials now. So there's so much to talk about. But we can Travis, any last words for this episode?
I guess just briefly, you had asked about the speedy trial. I mean, the way that works is if you're in custody, the idea is that the government can't hold you there indefinitely without you having the right to get in front of a judge and then ultimately to have your case tried. Otherwise, the idea is that people would sit in jail without being able to actually face their charges. And if they're, again, presumed innocent people are sitting in jail because they haven't been proven guilty. So the speedy trial right is to get cases tried so people who are not yet guilty don't have to sit in jail.
Yeah, and as to that point, it's often honored in the breach in that most criminal defendants, at least in the Bay Area in Florida, or at least a lot of them, they'll waive that right because you don't want to rush a knife either. The government generally, when they bring a case, they're ready to try it. If you're a good prosecutor, you're pushing it quickly, right? You want it to go quickly. The more confident you are in your case, the quicker you're moving it. On the defense side, time's usually on your side. If it happened or it's charged wrong, first of all, you need more time to investigate it. Witnesses disappear with time. Prosecution cases are like laundry that doesn't get better, right?
Right.
They kind of fall apart by attrition. So a good prosecutor's moving it time-wise. So that speedy trial right is sometimes something that is quickly given up.
Yeah,
Excellent.
It's very rarely ever something that benefits the defense, but every once in a while you might have one where somebody was just totally wrongly accused. You have a rock solid defense and they're sitting in jail and you're like, all right, we want a trial. Let's just be done with this because the prosecutor's not going to let them out because of whatever reason. And that's really what I think it came from, is like somebody who isn't put in prison by the king and they shouldn't be put in prison at all. There's nothing to back it up. So the idea is if the government really oversteps and is just trying to hold you in jail for no good reason, then there's this trigger that you can hit to get out of jail as soon as possible.
Well, gentlemen, fascinating conversation, and we've learned so much. Oh, Travis, were you going to say something?
I was just going to say that typically the government nowadays doesn't go to that extreme of abuse to where you end up needing it, like Paul was saying.
But sometimes they do.
But sometimes they do.
Well, again, fascinating conversation, gentlemen. Paul, always great to have you here. Travis, of course, so honored to be your host. And I'm excited to do another episode with you, Paul Cisco, and talking about COVID in the courtroom. But for now, stay safe, everyone, and thank you so much for joining us for this episode of We Trust Travis.
Thanks, everybody.
To
Thanks
learn
again,
more
Paul.
about Travis McConnell, head to travismclaw.com. Thank you for listening to We Trust Travis.